Now, if you're a regular watcher of these webinars, you'll know how this is going to go. We're going to be looking at 5 of the more interesting and hopefully useful construction cases from the first half of this year. If you haven't been with us before, you will find out a little bit more about how it's going to work, some of the context in which the cases are heard and determined, and of course how industry then responds to the jurisprudence which is made. It's a 30-minute webinar, and after this you'll have your multiple choice questions to answer. But in the meantime, I hope you enjoy this webinar and find the cases that we look at useful for your practice. The court went on to observe that the more carefully drafted the clauses, the more weight would be given to the actual words used over the commercial context or the common sense context in which the contract was made. Now, there is a trial which has been forward booked for October 24 on the back of this. Let's see what happens in the next 9-10 months or so, and whether that trial will actually go ahead. We'll be watching for it, of course, and if it does go ahead, we'll be hoping to feature it in one of our next construction case law updates. There was a bit of a commercial tangle here for the court to unpick. The court did acknowledge and state that actually it was very helpful to have the various skeletons that were available. So if you're involved in one of these types of cases, then do pay attention to that documentation that you're putting forward. Give the court as much help as possible to give that swift decision. The court will act to manage the case as fairly as is possible, of course, in balancing those competing demands. And as usual, in respect of payment disputes, the advice is to keep really good quality records, full records in relation to your applications for payment and valuations, and of course, to follow the contract's payment process.